Hey, Tim Lambert with the Texas Homeschool Coalition here with another legislative update. Today's April the 20th. We spent all day in Austin yesterday with the great THSC legislative team. We were coming down for a hearing on some parental rights bills in the Juvenile Justice Committee in the Texas House. So I want to talk to you about two bills that showcase the dichotomy between the worldviews of how to assure that we protect our children. One of those is the parental rights approach, where we believe that fit parents have the best interests of their children in mind. The other view is the liberal view that we need to depend on the government to decide what is in the best interest of children. So I want to talk about two bills that we looked at. One was House Bill 1899, a bill that we went to Representative Sanford and asked him to carry for us that would define a fit parent and would give some protections to fit parents. The other is House Bill 3806 by Representative Harold Dutton that would expand the opportunities for fit parents to be sued by non-parents. So let me start with House Bill 1899. It was a bill that takes the language from the Troxel U.S. Supreme Court decision in 2000 that essentially ruled that fit parents are those who adequately provide for their children, and they are presumed to do and to want what is in the best interests of their children. So this bill defines fit parent, puts it in the family code, that language from the Troxel decision, and then it limits Texas judges and does not allow them to do temporary or permanent orders related to the children of fit unless they can prove that the parents are unfit. So it seems like a common sense approach to us, but the trial lawyers, the Family Law Foundation, and the CPS advocates all opposed the bill. They argued that we were putting parents' rights above children's rights. I loved Representative Schofield's comments, however, when he said, "Are you trying to tell me that a judge who does not know a child is better equipped than a parent, a fit parent who's brought those children into the world, who's raised those children, who's provided for those children, that he's better qualified than them to decide what is in their best interest?" And that pretty much typifies that discussion. So when we got to House Bill 3806, that legislation is on the other end of the spectrum. That legislation would broaden the opportunities for grandparents or in-laws to sue their fit parents for access or possession. So essentially that would mean that any grandparent can sue any parent in Texas, not have to prove that they're unfit, abusive, or neglectful, and in fact it lowers the standard of evidence required to be proven so that expert testimony is not required. So again, we had the same kind of testimony, and it shows that this group of trial lawyers and CPS advocates do not believe that fit parents can be trusted, and they would rely on judges and the government rather than parents to decide what's in the best interest of the children. So I'd urge you to go listen to the testimony on these two cases if you have the time. I know it's long, but it gives you an idea of what we're up against. I'm glad to say that I think the committee is receptive to our approach, and we'll continue to monitor these bills. We'll let you know if you need to take any action, and thank you for your prayers and support in helping us keep Texas families free.